All right, there was an article that came out, I believe it was yesterday, from Childersburg, Alabama, where a local pastor ends up getting arrested by the police for the shocking crime of watering his neighbor's plants while his neighbor is away. Now, actually, of course, the cops didn't actually arrest him for that in the report. They arrested him for obstruction, also known as contempt of cop. So this is according to, I'll post this, but it's WIAT in Childersburg, Alabama. Michael Jennings, who is the preacher at Vision of Abundant Life Ministries in Sylacauga, has been in ministry for more than 30 years. And Sunday after church, he went over to his neighbor's house to water the roses. Some other neighbor, apparently a Karen, didn't immediately recognize who he was and made the unfortunate mistake of calling the police to report a suspicious person on someone else's property, apparently. So, of course, officers responded. They made contact with Mr. Jennings, who did not have his identification on his person. Now, he said that he did tell the officers who he was and why he was there. He said, "Give me some ID." I said, "No, I don't have to give no ID because there ain't no crime been committed." I said, "But what I will do is tell you that I'm Pastor Jennings and I live right across the street right there." And I said, "You can go ask my wife," which sort of reminds me of a Charlie Daniels song. Now, Jennings said that when he continued to water the plants, he ended up being detained. The sergeant then shows up. He's already mad. He gets out of the car, and Mr. Jennings says, "You're making a mistake. This is wrong what you all are doing." And he says that the sergeant yelled back, "Shut up and listen, you talk too much." I said, "You don't tell me to shut up, boy. I'm a grown man." Now, things always go well after you. I believe he said that to the cop, called him boy. I once had a case that came out of calling a cop boy, but that's another video. Then he said, "You're going to jail. That's it. Lock him up." So, the original neighbor who called police told officers that she made a mistake and begged them not to arrest Jennings once she realized it was her friend and neighbor. The woman's account is detailed in the police report, but he was still charged with, get this, obstructing governmental operations. When asked if there was any reason that Jennings would have been required to show identification, the police said, it would have depended on the circumstances. And apparently now they're investigating. So this is something that I've seen before. In fact, I have a case just about to go to trial where a black man was arrested in West Virginia for the very suspicious activity of performing utility work on a utility right-of-way. What was he arrested for? Same thing. Alleged failure to provide ID, i.e. obstruction. So in both sorts of scenarios, you have no actual crime that was committed, but somebody calling police for whatever reason, and then when the police get there, they want to assert their authority. And if whoever they encounter doesn't immediately submit to their authority, well, pursuant to their training or lack of training, whichever it is, they'll just go ahead and take that person into custody. And no crime has been committed except for the alleged obstruction or alleged failure to provide ID. Now, this begs the question, are you required to provide ID in such circumstances? Now, generally in a traffic stop, that's not really an issue because you already have the existence of reasonable suspicion, because assuming that there has been some observation of a valid traffic violation, that's automatically going to qualify as reasonable suspicion for an investigatory detention, i.e. traffic stop. But where things get interesting is when you're dealing with pedestrians. As I've said before, as a pedestrian, you have many more rights under the Fourth Amendment than you do when you step into your car. So there's a lot that really we don't know from this article, and specifically what I would like to hear is, well, the neighbor who called police, what did she actually say? What did she allege? Did she say, "I see somebody watering my neighbor's roses"? Or did she say, "I see somebody who appears like they're engaging in some sort of criminal activity"? Now, reasonable suspicion is required for any sort of Fourth Amendment event, any sort of seizure. So it's required for the stop of a vehicle. It's required for the stop of a pedestrian. Note that so-called consensual encounters do not trigger the Fourth Amendment. So like the rest of us, police can walk up to people on the street and they can have a consensual conversation with them. They don't have to say, by the way, you're free to leave. They can just have a conversation, and so long as it's consensual, the Fourth Amendment isn't triggered under the law. So no reasonable suspicion is required under those circumstances. Now, when do those circumstances exist? That can be a trial right there. That can be a jury issue right there. So as a general matter, police officers are free to approach and question individuals without affecting a seizure. So a person is seized within the meaning of the Fourth Amendment only when the officer, by means of physical force or a show of authority, has in some way restrained the liberty of a citizen. So the first real question to determine is whether or not a seizure has occurred. Of course it did in this case. The guy was actually arrested. But sometimes that's not necessarily the case. So how do the courts determine whether or not there's been a seizure? So a seizure is said to occur when, after considering the totality of the circumstances, the court concludes that, quote, a reasonable person would have believed that he was not free to leave. So when police approach a person at a location that they do not necessarily wish to leave, the appropriate question is whether that person would feel free to terminate the encounter. This is an objective test, not a subjective test. So it's not whether this person actually felt like he was free to leave. It's whether an objectively reasonable person would feel that they're free to terminate the encounter, to walk away. And a lot of times that's why people who've researched the law will say, am I being detained? Because then that is really taking all the guesswork out of it. The police officer says, no, you're not being detained, in which case you're free to go. Or they say, no, you're not free to go. And that's often the situation where police are asking for IDs. All right. What is reasonable suspicion? What is the legal standard? So reasonable suspicion is a common sense, non-technical standard that relies on the judgment of experienced law enforcement officers, not legal technicians. So what does that mean? So the courts require the detaining officer to either articulate why a particular behavior is suspicious or logically demonstrate, given the surrounding circumstances, that the behavior is likely to be indicative of some more sinister activity than may appear at first glance. So what does that mean? It sounds like absolute nonsense. The most important thing is that the suspicion by the police officer has to be particular to that individual. It can't be just categorical or generalized. Obviously, it can't be because he's a black guy and all black guys are suspicious. It can't be because he's a man. It can't be, it has to be particular to the individual. Secondly, it should be based on suspicion of illegal conduct. Now that's why I would like to hear what the neighbor alleged, as well as what the police observed when they got there. Watering your neighbor's roses is not illegal conduct. If that is all the information that the police officers had, there can be no reasonable suspicion there. Now, if it was alleged that it appeared to be a burglary in process, now that might be different. That burglary is illegal conduct. So it has to be particularized to the individual that the police are encountering. And secondly, it has to be based on suspicion of illegal conduct. So that's basically what reasonable suspicion is. Now, an officer must either articulate why a particular behavior is suspicious or logically demonstrate, given the surrounding circumstances, that a behavior is likely to be indicative of some more sinister activity than may appear at first glance. So this comes up in like open carry type cases, where a police officer, because freedom is scary, might be subjectively afraid of firearms. They see somebody open carrying, even though it's completely legal, in their mind, it's suspicious. Well, where you get into tricky situations is where police officers are encountered with completely lawful conduct and they try to make a case of reasonable suspicion out of completely lawful conduct. So in that case, it's up to the police officer to articulate why they thought that they had reasonable suspicion. So these are the sorts of situations that can be really tricky. Pedestrians, a call from a Karen, and you in the end have to look at the totality of the circumstances. Now, what do we know from this case? Just looking at the totality. All right, just say that there's a very vague call from a Karen saying there's a suspicious guy. The police get there, they observe this, 50, 60-year-old pastor, well-dressed, who says he lives next door, who says he's a pastor, who appears to be watering roses, and says he's watering roses for the neighbor. That, just looking at the totality of the circumstances, that is, little something less than reasonable suspicion in my mind. I'm sure it's not going to be an easy case to defend from the police. It looks like more like a reaction to, well, you didn't respect my authority, and so I'm going to teach you a lesson sort of deal. So we'll have to keep an eye on this one and see how it turns out.